Mr. Knox.
My lady, three very brief points. One is the case my Lord Justice Snowden referred to as Brendan International. We've got it. I don't know if it's on your...
It's Brendan International.
Oh,
but we've only got a little extract from it here. Do you want us to look to... Thank you.
As I understand it, the relevant passage begins... the point of principle rather than points of fact begins at para 91.
Well, yes, I mean, it's 74 and running through the law.
Yes.
And it's, as I said, it's Cleveland Bridge and Engineering, and then not doubted in Rogers and Hoyle, which isn't actually a case of quite the same species. But, and then, basically saying you can get it in, the evidence can come in, it's admissible, but it's subject to discretion to exclude it if it's an abuse of process designed to circumvent a direction for CPR compliant evidence, and in any event it's always subject to weight, i.e. is the person sufficiently experienced to give the evidence, and if he's up against a CPR compliant independent expert, he might well be disability or not be
at a disadvantage.
Yes, that's true.
Well,
And Mr. Knox, as I understand it, in this case, there wasn't an order in relation to expert evidence at all. The matter was, am I right that the matter was just raised, flagged up, and no one took the opportunity?
That's right. Yes. I think an order was made. If you want to apply for expert evidence, you can. I think that was the effect of the order, but no one did. Is that right?
So, before the Deputy Master at the CCMC, there was an order for three separate disciplines for each party. One, land valuation, two, trademark valuation, and three, Swiss law, if required. My client called at trial expert valuers, both two separate people, one for the land valuation and one for the trademark valuation, but did not call neither, and the defendant, respondent, instructed and called no expert evidence on any of the disciplines, and neither party decided to call experts in Swiss law.
Thank you.
If I could just qualify that. At the time the Swiss law point was raised, that was, I think, principally to do with, I'm pretty sure it was to do with the question of whether the rights of JOP had passed to the claimant, Carlos. That was the point in issue at that time. The amended defence, with all the representations we rely on, was actually served considerably sometime later in 2022, but afterwards. And there was then no further direction either way.
Do we have the Deputy Master's order in the bundle?
We do.
I don't necessarily want to go to it, but just the reference would be.
We do have it. Perhaps I can give the reference.
Yes.
It's there.
It's in tab 7 of the supplemental, my lord.
Thank you.
But I would simply say that this is not. There's no undermining here, and there's no reason why, as it were, neither party having called evidence of Swiss law that wasn't proper to put the question in cross-examination and get the answer I did. That's not undermining the court process at all. We're doing what Lord Legate said one can do. We call no evidence, but one's entitled in my submission to ask questions. And if you get a clear answer in cross-examination from someone who obviously knows what he's talking about, that is admissible. That's my submission.
Well, anyway, there's no objection to you asking the questions.
No.
Yes, I mean, now that I've looked at the order, not quite as you, Mr. Blake, had told us. 12 was the parties that to consider whether it's necessary to instruct an expert in Swiss law, and in the event that they decide it's necessary, they should apply for permission. And then 13 is trademark and real estate valuation. So there wasn't really an order either permitting or refusing it.
It was not. It was an option.
Yeah.
Come back later if you want. So that's one point. The other point I just wanted to mention is this. I did mention there are certain reductions that need to be made from our second ground, let's say the claim I first dealt with, which stood in the judge's judgment of 1.124 million, but there was a reduction in one respect to deal with the wrong exchange rate I'd adopted. For 100,000 Swiss francs, it should come down to 83,500 euros. That's a reduction of about 45,000 odd. And then there was another reduction from 63,751 in relation to community charges, I think, which I accepted have to come down to 51,667. If the total deductions there, or reductions, has to be 57,250 from the original claimed amount, and therefore 1.124 million referred to by the judge comes down to 1066749. 1066749. 1066749.
Thank you.
The other point is this: it's about Mr. Felipe Ortiz-Patino's evidence. So I think it's my fault. I didn't take you to another passage which was relevant on the question of contingent liability, and that is at S30, supplemental bundle, page 30, line 4. In summary, what it comes down to is this: you won't get a building license till you pay the relevant fee for the declaration, but you're not released. But your liability to pay is not contingent upon your actually applying for a building license. You are liable anyway. It's just you're never going to get the building license unless and until you have paid, but you're liable to pay come what may. And that that point, I think, comes across more clearly at a reference I should have given you. This is page 30, line 4.
Well, it doesn't help me at line 4.
Sorry, 30.
Page 30, supplemental bundle, line 4 said the Declaration d'Interés Touristique was also approved by the Andalusian government.
Sorry, continuing down to 18, my lady. Forgive me.
Oh, I'm sorry.
Not very. I just give context.
I'm not sure that helps me very much more either.
Well, you're not going to get your license to dig, that's for sure, until you pay. And that the town would have engaged procedures against the owner. In other words, my lord, and this is clearly what was meant, was you are liable in any event to pay. The liability has arisen, and further, you're not going to get your license to dig until you've paid. But you're liable. But even if you don't pay, and even if you don't get your license, you're not. Even if you don't get your license, you're still liable. And that's what happened in this case. No one suggested we got a license to dig. We were just sued. And I speak from recollection, but I think it's right, that we did have in the bundle at the trial a translation of the I can check this, a translation, I think it was indeed a translation of the claim made against us by the town de Castellar, saying cough up. And it was pursuant to that the settlement was reached. And so the point I make is there's no doubt the settlement was reached. There's no doubt the liability was eventually incurred. And what is more, it was incurred without there ever being a building license. So that's why I say this passage supports the reality, which is you're liable anyway. But the one thing that's not going to happen, you certainly, if you want to get your license to dig, you've certainly got to cough up. But even if you don't, you're still going to have to pay because it runs with the land. You've got your declaration, which is of value.
I think that what you've referred us to also needs to be read in context of what's on page 31, but I don't want to stop you now.
No, my lady, that's right. I was also going to mention that. You can't materialise your rights until you get the licence, but you're not absolved from the liability in the first place to pay. And that's certainly how the judge interpreted it, and in my submission correctly. I don't think it was ever suggested that this wasn't a contingent liability because there was no actual liability at all until the building licence was obtained. You never got the building licence, therefore you never had a liability. And the reason that wasn't run was because we had to pay anyway without a building licence. So that's my answer on the contingent liability point. I just turn now very briefly to the three other debts. There are three other liabilities which we say were
Actually, sorry, just to be clear, the judge was actually therefore wrong at page at 295. Or at least if the judge was recording an agreed position, the agreed position was wrong because it was an actual liability.
Well, yes, it probably is an actual. Well, it's actual, but you don't know how much it is. What is the contingent element is how much.
You have to negotiate with the town.
There's an actual liability, which Mr. Ortiz-Patino said was never going to be naught.
Okay,
But
so
the
the
actual
contingency is in a sense reaching agreement with the. Okay, got you.
The other three debts, there are three other liabilities my client assumed under the SPA. I can deal with this, I hope, very briefly indeed. That is at page 80, tab 3, in the supplemental bundle. And you'll see 1.3A2, the debts to be assumed by the purchaser, that's my client, pursuant to 13A above, the assumed debts are as follows, and the relevant ones are the one of 575314 at subpara 1, owing to Barclays by Besser. So that's obviously an important, relevant debt in this case. That being secured on Califondo. So you see that's being secured, what that is secured on. Then the next one is over the page, 1.3A2, subparagraph 3, sum of €864,000 being the principal amount plus all accrued interest, owing to the Caixa by Besser, and that's secured on Cali Ebro. And you have to take that together with number 8, which is 919933, again owing to the Caixa, of 885, and that totals 1783079. That's the second of the, as it were, debts we claim, a total of 17839 being a total of 3 and 8. And then the third was a loan of 1484775 owed to Sabadell at subparagraph 7.
So wait a minute. Are 3 and 8 different debts?
Yes, they're different debts, but owed to the same bank.
Oh, okay.
That's why I put them together. And the total, I think, should be 1783009. 1783079. Now, I say these are all, therefore, financing debts that were in existence and were over Balsa and Besser as at the date of the profit share arrangement, and therefore they fall within 3.3.1. I don't know to what extent that was really disputed, but I say it's clearly the case, and they are. You can see they're secure. They're owed, and I think, save for number 8, I think they're specifically said to be secured on particular plots. Now, the judge refused to give us an allowance for these debts. We'll ask why.
But just to be clear, if you're not selling the relevant property over which the security existed, and the relevant sale of the relevant asset as defined, whatever it is, I've forgotten the exact wording, the real estate asset as defined is the sale of the Soto shares. Why does a loan, a debt owed in relation to Besser and secured over a real estate asset that was not being sold fall within 3.3.1?
Well, these are financing liabilities we have assumed, so MGI becomes liable to pay them. Yes. I take your lordship's point. I think the answer is on a sensible expanded definition of 3.3. Otherwise, otherwise one lands up with taking on a whole pile of debt, or which is.
Well, no, I mean it has to be the net profit attributable to a sold real estate asset shall be calculated by deducting from the price paid for the relevant real estate asset the following items: bank facilities or other financing secured on or utilised in relation to such real estate asset. Well, you're trying to say, well, okay, this is a sale of the Soto shares,
Yes.
but the bank facility or finance is secured on real property in relation to loans to an asset which was not being sold.
Well,
It's quite a big expansion, isn't it? Just like I'm sure it had something to do with it, so we might as well just deduct it now.
It is a big expansion, but that goes back to my point on the first yesterday's on. I do. But I say real estate. If one gives real estate asset the meaning of
but you might give it a sort of a broad meaning, but there's a complete disconnect between the real estate asset being sold and the security over the real estate asset, isn't it? You're talking about at least two, possibly three different quotes real estate assets.
My lord, that may be right, but of course what's being claimed here is a profit share of Soto based on the value, eventually based on the value of the underlying properties. I do see what you're saying, but what I say is if you take an expanded definition, you treat real estate asset as constituting either over the Soto shares or over the shares or the properties of the companies which Soto owns.
Well, let's just do the whole lot then.
Well,
Okay. All right,
I
sorry.
understand your lordship's point,
Yes, right.
but you have my main point. I say all this is, in one sense, I agree. I say all this is
I know.
pie in the sky. But on the other sense, is if you're going to have expanded meanings, you've got to have, as it were, contrary expanded meanings on everything. And if that's right, then I say, I might add this too, my lord. I don't think your point was taken before the judge, or indeed in the appeal. So, no surprises, I suppose, for the court to take the point the first time. But that's my answer.
Somebody might disagree with you, but we'll have the chance to say.
But anyway, I say, within the expanded definition of 3.3.1, these are financing debts over, quote, Soto or its underlying assets. That's what it comes down to. And therefore they come in. The question, therefore, on the face of it, we're entitled to a deduction for them. Why are we not given one? And the answer is set out in the appellant's arguments, which we say, far from justifying a refusal, actually explain why they should have been. And in broad terms, I'll take you to the reference.
Can we just see where the judge refused them? Is it just the schedule?
Yeah, he just refused them in the schedule.
Can you tell me which lines of the schedule he did that in?
I should have made a reference to it. I don't for the moment, but perhaps, my lord, my junior can dig that up. But he simply deals with it in very summary terms. He makes no alterations to the judgment. Because we had said you've forgotten about these debts. Okay. And then we put a note in, my learned friend puts
My lord, it's not in the schedule. It's actually, he amended a line in the body of the judgment just before hand down.
Which is that?
And that's what my
Okay,
learned junior
thank
is
you.
just going to give me.
Well, let's just wait until light dawns, but do carry on, Mr. Knox, in the meantime.
I mean, in essence, what happened is the judge thought these were not being claimed. In fact, they were. There was a misunderstanding. I wrote a note saying you've forgotten about these three debts. My learned friend said, oh no, these debts anyway would not be properly deductible. And the judge, and they gave an argument, and the judge basically said in a note, side note, shortly before handing down the full draft, I agree with the claimant's submissions, and therefore I'm not making an allowance for them.
And I can give you now the reference.
Thank you, Mr. Blake.
It's paragraph 254 of the judgment, but it's on page 102, and he added in the words, it's about 6 or 7 lines down, he added in the words, or specifically relate to assets that are not sold under the 2015 SPA.
I see.
Yeah. Okay. So in fact, he is saying that the costs relate to something which a real estate asset which was not being sold to Zagaleta.
To which we say, precisely. That's our point. Because what happened was, these debts only got written off because the relevant properties, which we have bought, had to be sold. And so what happens is, A, we take on the debts. B, Zagaleta does not itself relieve us of those liabilities as part of the consideration, because the underlying property and the debt has gone. And so we say, that being the case, there's no reason why we shouldn't have the credit, because we assumed the debt in the first place, and the only way we got rid of it was by having the property flogged. So if we'd assumed a debt of, let's say, 2 million, secured over a property, and that way the property is then forced, there's a forced sale, and that's the only way we can get rid of the 2 million, we've landed up with nothing. No profit there at all. I give that as a sort of very simplified example. And that's what the judge said, it's only if Zagaleta itself paid on, or rather, it's only if that was part of the purchase price, like the 8.8 million. If that was part of the purchase price, then you can take it as a deduction, like the 8.8 million. But as it wasn't part of the purchase price, you can't have it as a deduction, which would say that doesn't follow at all. The point is we did take the liability on, and we never got rid of it except by selling the asset over which the liability was sold. Hence, we're entitled to a deduction. Now, the passage, or rather the arguments, are developed in my learned friend's note at page 212, the 1.48 million debt.
But this is in the core, yeah?
No, I think supplemental. I apologise.
This is some argument below, is it?
This is the argument accepted by the judge, yes. Claimant's argument.
212?
206, sorry, 202. Sorry, 202.
Quite a lot.
This is where it begins.
201.
It begins at 201. But the relevant passage for the debts in question begins at paragraph 6 on 202. The loan of 1.48 million owed to the Bank of Sabadell. So this is one of the assumed debts. How did it disappear? Now, the sting is in paragraph 12. They say it constitutes double counting if we were to be given the credit for this. To which we say it certainly doesn't constitute double counting. It's the precise opposite. We have taken on this debt as part of the consideration, and the only way we got rid of it was by selling the assets we acquired. I say we, I'm speaking very broadly now. That's not double counting. It's just counting it once. And the same point arises in relation to the 575 million debt, 204, paragraph 17, paragraph 17 to 21, Paragraph 24 makes the point again. So essentially, this would be double counting to take it into account. And then finally, paragraph 26 on page 206 deals with the 1.7 million debt. 6 to 31. It's the same argument each time. We say, well, that argument goes nowhere. That's the reason why we should be given credit.
But the judge decided on a different point. He just said it doesn't relate to a real estate asset sold.
Well, sold to Zagaleta.
Yeah.
But it doesn't. But in my submission, that was wrong. It doesn't matter whether or not the real estate asset was sold to Zagaleta. That has no... the point is, it was an assumed liability in the first place. We've taken that liability on. And the question is, have we been able to get Zagaleta to take this liability on in addition to the 20 million?
And the question is whether it falls within clause 3.3 and you can deduct it for the purpose of the profit share.
Yes, well,
which is triggered by the sale of the Soto shares to Zagaleta.
That is right, but the profit share is. But I might have incurred all sorts of financing.
But not in connection with the sold real estate asset, because that's the shares in Soto.
My lord, on that point, you have my argument. I say it was on the broad I submit only sensible interpretation, broad interpretation. This is a financing liability we have taken on, and never been able to recoup. On a broad approach, I take the narrow approach, fine, but I submit that that would be, if I may say, produce a perverse result, as perverse as the results which have been alleged against me. That's one of the problems in this case.
I think we have your point. Thank you.
That's it. Thank you, my lady.
Thank you. Mr. Blaker?
Thank you, my lady. My lady, I'm going to deal with grounds 1 and ground 2, and Mr. Kwok will deal with ground 3, as I mentioned yesterday. In terms of those first 2 grounds, I am going to begin with the concept of the exclusive jurisdiction of the Swiss courts. Then secondly, I'm going to look at Swiss law, and I'm going to break that down into 2 particular parts. One is the law that relates to looking at foreign law, and then a more specific analysis of what actually the problems would be in this particular case with the circumstances of this case. And in my submission, there is absolutely no error on behalf of the learned trial judge. What the judge has done, and one sees this at the turning to the section where he goes on to Swiss law, which begins at 268 of the judgment, is he makes it absolutely clear from paragraph 273 onwards that he does not need to determine these questions. So he is not going to determine the issue in relation to Swiss law, and he makes it absolutely crystal clear in 273, I do not do so. Now, what Mr. Knox hangs a great deal on is the fact that then some comments were made, but in my submission, there was absolutely no indication, because he makes this same point a number of times, absolutely no indication that he's making final findings of fact. He is just setting up an introduction, a sort of prologue to any potential decision making, but he can't go that next step. Mr. Knox essentially wants this court to take a leap, which is that the learned deputy had actually made findings, and that it can be presumed that Swiss law would apply exactly the same way as English law.
Well, what did the judge mean in 273, where he says, in case this matter proceeds further, etc., etc.? I mean, he's writing the rest of it for the benefit of this court in case the matter proceeds further. I mean, what does he mean if he's not doing that?
Well, it isn't necessarily... I don't know what he's actually saying, but he says, of course, in a number of different places, my lord, he says, I'm not actually... all of this is caveated with, this is all subject to Swiss law, and that is an insuperable difficulty.
Well, I understand what you say about Swiss law, but put that aside, is he not doing what you would expect a judge to be doing in these circumstances, which is finding any relevant facts that he can find apart from Swiss law?
Yes, I mean, I accept that. my lord, that he goes up to a point. But as I say, one can only view that as sort of chapter one of the narrative, because he makes some findings of fact, but there is then this hurdle because he doesn't know, and none of us do in this courtroom, as to how those facts can then be applied to the relevant law. And of course, my lord, the Swiss law may well treat facts in a very different way. So it's essentially it is very much falling within his comments and some comments, and rather not going further. And what he doesn't say, and one would expect he's not saying, is, and I'm reaching these firm conclusions.
He's not deciding the whole claim, but he's saying, subject to Swiss law, these are the conclusions that I would have reached.
Yes, I'll go as far as accepting that, my lord. But what he does say, if I just take it on to another paragraph at 275, he says it doesn't require this court to determine the claim. And again, in terms of the jurisdiction question, he says he doesn't need to resolve that. So
right.
Again, there's no actual firm resolution on that question of jurisdiction. So we have two problems. One, he's not actually made a finding on jurisdiction, but then he's also not made a finding on the applicability on the applicability of Swiss law and how that would apply to any factual findings that he's made. So we see that at 275, and then we also see that again at the bottom of 293 and at the bottom of 295. And the difficulty, as I say, whilst he's written some comments on fact, what we don't know is what fact-finding exercise a judge in Switzerland, applying the law in Geneva, in the courts of Geneva, I should say, and applying Swiss law to breach of warranty and to misrepresentation or to any of the other issues. We don't know what other facts they may or may not need. So, for example, the point about access to local records and what access the MGI had to be able to search local records in the Castellar district, we have no idea whether that would be something that would be relevant or not.
So although you've accepted what Sir Christopher Floyd put to you about the judge is finding what he can apart from Swiss law and you say jurisdiction, actually you say whatever he might have found is useless because we don't know how the Swiss court would have approached it. So in fact, you say more than what you agreed to. You say actually
I say a bit
it's
more.
written water.
I say more.
Don't you?
I do say more than that, because I say that what Sir Christopher Floyd put to me is, yes, there are factual findings up to a point, but what I say is that if one knew and had a clear understanding of what Swiss law needed in order to...
You say they might be worthless.
It might be. It might not be. But I just don't know that, and we don't have that information before us. So if I can just develop the argument on the jurisdiction point. What we say is that it might be worth just looking at clause 8. Sorry, that's in the supplemental, isn't it? At the beginning. Tab 1. Set off at page 11. The profit share agreements, obviously English law applies, and we have the set off that we looked at this morning. And one can contrast that with the share and purchase agreement, where we see at page 99 of the supplemental bundle at 10.10, governing law and litigation. And what I submit is that this is a very widely drawn provision. Of course, this is the main provision in the sense that this is the governing document that deals with the purchaser and the acquisition of the SOTO and...
So what is? Clause what? Which
10,
of the clauses?
10.10. I'm talking about the whole agreement being... I say that this relates to the whole acquisition of the shares in SOTO and Campo. And we see governing law and litigation. It should be governed and construed in accordance with the laws, substantive laws of Switzerland. And then in B, and then in my submission, this is widely drawn. Any dispute, controversy, or claim arising out of or in connection with this agreement shall be subject to the exclusive jurisdiction of the ordinary courts of Geneva, save for a possible appeal to the Swiss Supreme Court in Lausanne. And whilst the learned deputy judge did not make any final findings on that, in my submission, just as a starting point, when looking at clause 8, this, in my submission, amounted to even if a claim had not been actually commenced in the Swiss courts, if it was a dispute or a controversy, it has to be brought within Switzerland, within the courts, particularly of Geneva. And it would be for the Swiss courts to decide and determine a genuine pre-estimate in order to be able to set off under clause 8.
Well, how can that... It says a genuine... Well, I mean, first of all, the question of whether it is a claim falling within 8.1 is a question of interpretation of this English law agreement.
Yes.
Even though the claim itself, if brought, would have to be brought in Switzerland by proceeding. That's the first point, I think, against you. And the second point is, why do you say it had to be the Swiss court that had to make the genuine pre-estimate? Because under clause 8.1.2, it clearly says it should be a genuine pre-estimate by the purchaser. It doesn't say by the Swiss court, it says by the purchaser. And that's the interpretation of that phrase as a matter of English law.
But as my lord said, that's right, and I accept that point, but without there being then a determination of that issue, how could there be any operation of this in terms of actually understanding what the actual sum was that had to be deducted?
This is quite commonplace. The purchaser makes a genuine pre-estimate of the liability and withholds, subject to an adjustment when the claim is actually either settled or determined by a court of competent jurisdiction. The question of what is a genuine pre-estimate and whether it was permitted or otherwise by clause 8.1.2 surely is a matter of English law, because it's a question of what this agreement
Yes, and I accept that. I accept that, but the difficulty then is that at the point in time that one gets to where Mr. Knox says we should be making significant set-offs, I say that there's been no claim made in the Swiss courts. And I also say that those claims were, one of the arguments was that they were...
But you only have to be entitled to assert a claim. You don't have to, in order to have a set-off, you don't have to have actually made the claim. It says entitled to assert. But this is all a matter of English law interpretation of this agreement. If you'd have tootled off to Switzerland and asked the Swiss court to determine whether it was a genuine pre-estimate of liability, surely the Swiss court would have said, well, what's that got to do with us? This is an agreement governed by English law with an exclusive jurisdiction clause in favour of England. If the question of whether what's been done complies with this agreement is to be determined by the English courts in England.
And I don't disagree with that, but where I do take issue is that is that, for example, at 8.3.2, when dealing with how a claim's to be treated if it's settled, there it refers to a court of competent jurisdiction already having made that award.
Well, it would be the Swiss court that would ultimately
Yes.
determine whether the sale and purchase agreement had been breached or any warranty in it or otherwise, if a claim was brought. And it might be that there would be said to be some implied obligation if you've exercised the right of set off to actually issue a claim and get on with it. But that would be it, wouldn't it?
Yes, I mean, the difficulty with all of this is that, of course, the respondent didn't bring.
Yeah, well, you could presumably sue if there'd been a deduction here, and you thought it had been wrongly made. You can either come to the English court and say it's not a genuine pre-estimate.
Yes.
Alternatively, you could issue proceedings in Switzerland, presumably claiming that you're not liable.
Yes. But for me, that's right, my lord. Yes. In my submission, the significant factor. Firstly, I say that the judge didn't reach any actual conclusion on that issue, notwithstanding he was, and I accept, sceptical of my argument that, as I detect, my lord, is in that the court could not set off, but where he was in favour of the approach that I submitted to the court was in relation to the applicability of Swiss law and the fact that the court did not have that evidence before it. And what I say is that it is important. We've looked at Brownlee, but it's actually important to look at it in a little bit more depth than Mr. Knox did before the short adjournment. The starting point is that English law will apply until a party alleges that another foreign law is of application. There's no dispute in this case that in the defence, in both the original and in the amended defence, that it was pleaded that Swiss law applies. And we see, I can take my lady and my lords to the defence, to the amended reply, I should say. We see it in a number of different parts of the pleading. We see it at 28B at page 174 of the core. And we see it at paragraph 76 at 183. Those are two examples.
Yes.
Now, I've already taken you to the order of the Deputy Master, which Sir Christopher Floyd pointed out that I hadn't entirely, I misremembered quite how the Deputy Master had put matters. But he directed that consideration had to be given whether Swiss law, by the party, whether Swiss law was required. So at that point in time of the Costs and Case Management Conference, and through the reply, the respondent was perfectly aware at that point in time that a Swiss law point was being taken in this case.
Well, so were you. You were taking it.
Yes.
So it wasn't the onus to introduce, if you thought that there was something materially different in Swiss law than English law, the onus is on you to bring some evidence forward, isn't it?
Well, let me develop Brownlee, and I'll explain why that's not correct, my lord, and because the onus, of course, is on the defendant to prove its claim.
I thought the onus is on the party saying that Swiss law or any foreign law is materially different from English law to produce some evidence to that effect. Anyway, okay. So you say that isn't one.
Yeah. You just turn to Brownlee. Tab 7. And we begin at paragraph 116. The point in that paragraph is that if either party pleads foreign law is applicable, then it's the duty of the court to apply foreign law. And 117, if one looks at D, an English judge does not in that event still have to adjudicate, if by that is meant to decide the case by applying a system of law, English law, which has been shown not to be applicable. Rather, the ordinary consequence must follow if a party fails to prove its claim or defence, the claim is dismissed or the defence rejected. Where it's asserted and established that the applicable law is a foreign system of law, there's simply no scope for applying English law in its own right. Now, going on then to 118.
Sorry, just before we get... Sorry, 116.
Yes, my lord.
Sorry, you sort of skated over it, but at the end of 116, Lord Legate says, in accordance with general principle, the burden is on the party who is making or defending the claim, as the case may be, to prove that it has a legally valid claim or defence. Where the law applicable to the claim or defence is a foreign system of law, this will require the party to show that it has a good claim or defence under that law. I mean, he's just saying, if you assert that you have a defence under Swiss law, you've got to prove it, haven't you? Or if they said they've got a claim under Swiss law, they've got to prove it.
Well, that's what I say. They have to be able to prove that. They've got to be able to prove that.
Just on the burden of, but this assumes, because we're going to get onto this, this assumes that there's some difference between English law and the foreign law. If there's no difference, then...
Well, I'm going to develop that now as we look through Brownlee. And then at 118, Lord Legate says that there's accordingly no scope for applying English law by default. It follows that if English law has any role to play, it can only be on the basis of presumption that the content of the applicable foreign law is materially similar. Mm-hmm. Now, where he then goes on at 123 is to discuss that in common law countries that they may have the same...
Mr. Blake, we've been asked to read these paragraphs before, so
yes.
I think we've got a sense of them and what
yes.
Lord Legate was saying. Can you just point to the particular points for us?
Yes. Well, it's the limits particularly, and then I want to take you to some examples and some difficulties that weren't drawn necessarily to the court's attention. So if one can look at 126, because I do say there that there are limits, and then a number of cases are set out as examples where, in particular, non-common law jurisdictions about the applicability of the law in those situations. And I would ask you to consider, firstly, there's paragraph 129, which deals with French law. Paragraph 132 is a case of the United States Supreme Court regarding the law of Spanish law in Cuba. And then...
So which was the second example?
The second example, my lord, was at 132, that paragraph. 133 is a South African case in relation to Russian law. And then a more recent example that I wish to draw the court's attention to is at 136, which is a case from 1981, Österreich, where the case related to Austrian law, and the validity of the bill of exchanges between D&E was governed by Austrian law. Law Justice Roskell, with whom the other members of the Court of Appeal agreed, doubted that the relevant Austrian law could be presumed to be the same as the relevant as the relevant English law. Now I say, turning then over to the general guidance at 143. The first point that I wish to make at 143 is that it's noted that it's difficult to state hard and fast rules because it's fact specific as to when it may properly be employed. 144, Lord Legate says it's likely to be appropriate where the applicable foreign law is another common law system rather than a system based on Roman law. Now, pausing there, I mean, the Swiss legal system is a federal and cantonal system. This was subject to Swiss law in the courts of Geneva, and one doesn't know how that would necessarily apply. And at paragraph 145, at the beginning between D and E, he says, as a matter of broad generalization, the presumption is less likely to be appropriate where the relevant domestic law is contained in a statute. Now here, there are two aspects where I say that applies. One is the Limitation Act, and secondly is the 1967 Misrepresentation Act, which was also pleaded by the defendant. So it wasn't just a breach of warranty, but they were also pleading this as a misrepresentation. And so I say that, again, we fall into where Lord Legate says there, the difficulty of not knowing how Switzerland would treat a statute.
Okay, but those two are different. The misrepresentation as an alternative to contractual warranty is a claim made by MGI, and limitation is a defence asserted by you.
Yes, but I say, I mean, my principal submission is in relation to the misrepresentation, because it's in relation to the substantive matter of the set-off. And what I say there is that one doesn't know how a Swiss court would treat that issue.
But if they've got a claim in contract, do you say that there's any material difference between Swiss law and English law in relation to the interpretation of the contract written?
Well, I'm going to come to that in just a moment, because we've set that out in writing, but I'm just going to elucidate a little bit more on that, my lord. And at 140. 146 deals with the point, and we've already dealt with this in my Lord's questions. It's open to a party asserting a claim based on foreign law to adduce direct evidence of that foreign law rather than take the risk of relying on the presumption. But at 147, it ties this together in terms of the procedural context, because what Lord Legate says there is the procedural context in which the presumption is relied on matters. Self-evidently, there's more scope for relying on the presumption at an early stage of proceedings, when all that a party needs to show is to be allowed to pursue a claim or defence is that it has a real prospect of success. So, for example, in the Part 24 application, by contrast, to rely solely on the presumption to seek to prove a case based on foreign law at trial may be a much more precarious course. Now, in this particular...
But he says that, doesn't he? Because it's only a presumption.
Anyway, precarious or not, we've got the result of what happened at the trial, so we're not really considering how risky it was.
Well, what I say there is that this was an issue which was raised for the very first time on the 6th day of the trial by Mr. Knox. It didn't feature at any prior stage in any written argument in advance of the trial. It's only raised during closing oral submissions.
What, the presumption?
The presumption.
I don't think anyone had mentioned Brownlee until closing submissions. That's why.
And when tied together with the order from the master, the deputy master, and the fact that the respondent declined, for its own reason, to instruct a Swiss law expert, it took the risk that the judge was going to adopt the course that he did, which was to say, I can only take matters so far, provide some comment, and I'm not going to go on and presume that Swiss law and English law will deal with matters in exactly the same way. And his approach, when we look at paragraph 273, in my submission, is a perfectly appropriate approach, and this court cannot criticise the deputy judge for doing so. Now, I say that also then when looked at the specific points, there are problems with the application of the presumption. I've already mentioned the Misrepresentation Act. And then there was the contingent liability issue, where if I can just again draw your attention to Nortel, which we saw at tab 11. Now you saw the example that Mr. Felipe Ortiz-Patino gave of the driving the car without the license. And that point is essentially drawn out. And we see in Nortel, at paragraph 77, we have the three-stage test. And then if I can just ask you to look at 77, and then also in Lord Sumption's judgment.
Is 77 much help to us at all?
What I say there
I don't think so.
is that we don't know how Swiss law would treat a contingent liability. That's the point. It's a very short point. And what we have set out in writing, we set that out at paragraph 80. That is a nuanced test. And as we've said, there's every reason to think that under Swiss law, the definitions and the way the applicability of those principles may well be different. From paragraphs 82 to 87, we deal with, again, the difficulties of each particular stage. So, for example, we do not know what standard of care would be applied under Swiss law, whether negligent misrepresentations are permitted. We do not know about the scope of liability. Similarly, there's no understanding as to how Swiss law would approach the issue of causation and remoteness.
These are all just aspects of the fact that you say you don't know, Swiss law applies and you don't know how it applies.
Absolutely, my lady, and those are all set out there, and again, we have that again with damages. Now, to deal with the point at 86 of my skeleton about Mr. Vermeer, I accept, and I have to accept, the point that Lord Justice Snowden says in relation to admissibility. I've never sought to suggest that it wasn't admissible.
Yes, he did. Top of page 283. His answers regarding the Swiss law limitation are not admissible.
Well, it seems that Mr. Blaker doesn't now.
Well, what I do say, I stand corrected, my say that in writing. What I do say, though, is that he can't be used with the weight of an expert. And we saw in the, firstly, there's no suggestion that he was a disputes lawyer, but we also saw in the passages that Mr. Knox drew our attention to how brief the discussion was, and
You
how...
have to say it has no weight, don't you? Because
Yeah.
we're deciding a question of fact, although it's a special type of question of fact,
Yes.
and balance of probabilities applies. So if there's some evidence as to what the Swiss law is, even if it's not of enormous weight, or not of great weight at all, it tips the scales nevertheless. So the only evidence on the point.
It was the only evidence on the point, but it's a point that, unlike the points that Lord Justice Snowden, in the case of Brendan International, where one's dealing with an expert who's already perhaps giving evidence on a technical matter, and then further questions are being asked on issues that don't necessarily feature in that expert's report.
No, he was a factual witness. That's the whole point. He was a factual witness who was asked, or in fact had volunteered in his witness statement, his opinion as a person who'd worked in the sewage industry for 30 years as to whether it was a public or a private sewer. And the objection was, he's not an expert, he's a factual witness. And the judge says, I agree, he's not given his evidence in a CPR compliant form. And what we said was, it doesn't make it inadmissible that he hasn't complied with CPR 36.5.6, whatever it is. It's admissible, subject to questions of whether it's abusive and subject to questions of weight, as my Lord Christopher Floyd has just said. If that's what you've got in the scales, and it was admitted in evidence without objection, without anything else, why is the judge wrong why would the judge be wrong to rely upon it?
Well, I would say it's a matter that's only been raised through one question of cross-examination, or and so it's a point that's not even been flagged up in advance for the...
But your witness didn't say, that's a difficult one. I wish I'd had some advance warning of that. He just gave his answers. Well,
he gave an answer, but of course he gives his answer originally. His first answer is 5 years, and then he changes it to 10, and then Mr. Knox says, are you sure that is 10 when it comes to a commercial contract?
That's not how it happened. He said 5, and Mr. Knox said 5, or is it 10? And he volunteered, the witness volunteered that it was 10 in relation to a commercial contract, and explained the distinction.
Yes, but my point is that he wasn't given... he gives an off-the-cuff remark there, rather than...
Is he wrong? Are you standing there saying he's wrong?
I don't know that.
He's your own witness. Did you re-examine him?
Have you had a sneak at a textbook on Swiss law to see what the position might be? You haven't been tempted?
In any event, and it may be that what I say to this, and as a more general answer to all of this, is that only, in any event, would only get Mr. Knox over one of the many hurdles that needs to be jumped over in relation to the... because that only jumps over a limitation hurdle. And all the other hurdles that I've just mentioned to my lady and in relation to Swiss law, that's where the judge, perfectly properly in my submission, declined to go further because he didn't have that evidence before him. And in my submission, that was the correct approach for the court to adopt. I repeat those points at my paragraph 92, but in 93, I make 2 further points. One is in relation to, this is 93A, say it's a question of fact. It was already found there was no evidence that the IBIS property taxes and community charges predated the 2012 SPA. And we say there that the respondent should have been fully aware of those sums, or at the very least that was a potential defence under Swiss law. And secondly, B, that Zagaleta assumed that debt of 647,000 odd that was owed to the government, and that's referred to in the judgment at paragraph 295. And again, there's no finding that that was owed at the date of the 2012 SPA. And we don't know on what basis it arose. And as I say, it could well be due to the respondent's mismanagement, which the judge sets out at 100 and refers to at paragraph 128 of his judgment. And again, I say that as a matter of Swiss law, it would be, it may well be, or presumably under Swiss law, that JOP would not be held liable for that subsequent mismanagement that the judge has made clear findings on, as I say, at paragraph 128. So when it comes to those particular issues, these are matters that are A, covered by the Swiss law point, and secondly, are covered by all findings that the judge has already, that I say have already been reached in those paragraphs that I've just drawn your attention to. My lady and my lords, are there any other points? Otherwise, I shall hand over to Mr. Kwok.
No, thank you very much, Mr. Blake. And Mr. Kwok? You're dealing with ground 3.
Yes, my lady. My lords, the issue on ground 3 on the preliminary point of permission has been discussed, and I don't propose to deal with that. We've set that out in our skeleton argument in relation to Trinity Logistics. I think Mr. Knox does accept to some degree that he may require permission. It's a matter for him and the court whether permission is granted. I propose to say nothing more about that. What I propose to do is just to quickly go through the various sums in turn that Mr. Knox dealt with. The 3.5 million euro sum is the first issue. Mr. Knox, in paragraph 75 of his skeleton argument, page 314 of call, calls it, I don't propose the court necessarily needs to read it, but at this point, but he calls it about 3.5 million euros. It's not entirely clear why he calls it about 3.5 million euros. I mean, it's his defence. Doesn't quite know how much it is by now. And I must mention it's a bit late to clarify. But so that's the preliminary point. But the second point I want to make to the court is in relation to how the trial judge dealt with it. So if one looks at core page 97,
Yes?
246 little 2, Mr. Knox has taken the court to it, so I won't go through it in detail, but there is a mention of the penultimate line there of 3.5 million euros approximately. There is another reference to that sum at core 38, which sets it up in a little bit more detail, and is perhaps better at clarifying the circumstances of that sum. And Mr. Knox did briefly take the court to it, but I just want to revisit it again, if I may. Page 38 of core paragraph 66, little Roman 1. point there made at 4 lines down from the top of 1 is that the loan was made by Banif to Valderrama 07, which was expressed to be outstanding in the amount of, and there a precise sum is in fact given, 3505984, after setting off against these debts the various deposits of Banif, etc., etc. And then the paragraph just below that, the net amount is referred to in the offer letter as the net debt position. Now, Mr. Knox took the court to the underlying letter, but in my submission, it's not really necessary to do that. The point is, and the key point is that the 3.5 million euro odd and change relates to and is attributable to VO7. And it's common ground, or at least not challenged on this appeal, I think, that if a sum is attributable to Valderrama 07 or the Castellar land, which is the land that VO7 holds, or indeed Campo, which is the holding company of VO7, one level above that, that is not a claimable deduction. And just for the court's reference, I mean, my Lord Justice Snowden referred Mr. Knox to this, but just for the court's note, the judge dealt with this at page 100 of Core. Paragraph 251, little Roman numeral 2. So my submission now deals with that point.
So wait a minute. This is claimants for a deduction on the basis of an assumption by MGI, is this right, of a liability which was owed by VO7 to Banif.
Yes.
And it related to the Castellar land. Is that right?
Yes.
As far as we can tell.
Yes, as far as it appears, because VO7 simply held the Castellar land.
You say, and simply, it's just that's not the real estate asset that's sold to trigger the profit share, so you can't deduct it either under 3.3.
Yes.
And Mr. Knox's answer was, well, you know, if you're what's sauce for the goose is sauce for the gander. If you're going to have a profit share because you're going to interpret this net real estate asset widely to include the Soto shares, then we'd better read real estate asset widely in 3.3 as well.
No, because there are separate provisions in the PSA dealing with Campo or VO7 or the Castellar land. And there's a separate provision for what sums are valid deductions under that. So this is all hived off into clause, I think it's clause 5, I think I'm right in saying.
Because you're saying this is never a real estate asset of any description, certainly not one owned by Vesa or Balsa.
Yes.
And so you're drawing attention at 251 little 2 to the fact that the judge makes that clear that what one's needing to look at is real estate assets owned by Vasa and Vesa, and this was not. And then you're taking us back to the agreement and asking us, therefore, to look at clause 3 in the light of the fact that there are express clauses which deal with VO7 and Campo, etc.
That's right. Subject only to the caveat, of course, that we disagree that it relates only to land owned by Vasa and Vesa, but that's been dealt with already. Just turning to the other sums. Mr. Knox said, I think at one point, that the arguments that we have made and I am about to briefly explore were not taken at trial before the judge. I think he's mistaken, and the court looked at this when it looked at the post-judgment submissions, which are in the supplemental bundle. And just to explain, the court may not have appreciated this, but the reason why there were post-judgment submissions at all was because the judge had initially thought, when he served the draft judgment, that the sums being claimed by Mr. Knox under this heading were not being claimed at trial. And there was a correction by Mr. Knox at page 191 of supplementary, where he sends in a note dealing with a wide range of matters. He goes through various typos, but the key point is that he goes beyond suggesting corrections into making further submissions. And at paragraph 6 on page 195 is where Mr. Knox dealt with this matter particularly. There you see, the court will see the subparagraphs 1, 2, and 3 of subparagraph 6. The sum at subparagraph 3 being 1.957 million and change was a typo which Mr. Knox accepted at page 197. There's a main paragraph 2 and then a subparagraph 2. The judge is correct in saying that the total of the sums 864,919 is 1783 and not 1.9 million. And then we put in our note in response, starting at page 201. And the reason why I've taken the court through this is because I want to make absolutely clear, if I may, that this point was taken in post-judgment submissions only because we, like the judge, thought that Mr. Knox had withdrawn this claim. Well, that's what he thought. I mean, Mr. Knox says he clarified it. Of course, now he did, but then that's why we had these post-judgment submissions. And now we've dealt with it, starting at page 202. This is the first debt, 1.484. And the simple point, which is a point that my Lord Justice Snowden discussed with Mr. Knox, was that this sum was secured on Plot I properties that Vesa owned. And over the page at paragraph 10, we made the point that these properties were not included in the sale to Zagaleta. And under the 2015 SPA, Vesa was treated as though it did not own the Plot 1 properties. The reason it being that they had been foreclosed upon in 2014 before the 2015 SPA. But there was a further point that we made in terms of the evidence, and one sees this at page 204, at paragraph 14, which is that actually, putting aside the point of principle, there wasn't even any evidence that MGI had made any payments to the bank, and there was no evidence either that after the 2015 SPA there was still a debt owing to the bank. So the point was raised. And the point of principle that arises from that, as I think my Lord Justice Snowden said, is the real estate asset, being Soto, did not control the Plot 1 properties anymore. From an economic perspective, the price achieved in the 2015 SPA did not include the purchase of, shall I say, control over the Plot I properties. So if one looks at how net profit is calculated, you take the price, you take away deductions, you get the net profit, but we don't even get to the price as far as this debt is concerned, because it was discharged by the foreclosure of the relevant properties. And the same point, I mean, it is exactly the same point in relation to the other two debts. I mean, the court will be able to see that at pages 204 to 206 in relation to the €575 debt and the our submissions at pages 206 and 207 of supplementary dealing with the 1.783 euro debt, which is an amalgamation of, as Mr. Knox said, 864 euros, 1,000 euros and 990,000 euros. I'm told I haven't missed anything. So if my leader says I haven't, then I haven't. I'm very grateful, my lady, my lords, unless there are any further questions.
No, thank you very much indeed, Mr. Cork. Mr. Knox?
My lady, briefly, I endeavour. There's a point about on what I call our second ground, which is just the deduction for miscellaneous financial liabilities. My learned friend takes the point that Zagaleta assumed the VAT liability of £674,000. But in my submission, that is entirely irrelevant. What happened is this. Because there is this liability, undoubtedly, we say undoubtedly, this liability exists when it shouldn't have existed, we pay essentially €674,000 over the odds, because there's this non-disclosed debt. We should have been told about it. Had we been told about it, we would have been able to say, right, we want 674,000 off. That's the starting point. We then carry this debt throughout our period of ownership. The consequence of that is just at the moment before we're selling to Zagaleta, we have assets which are €674,000 less than they should be, because we're carrying this extra debt. When I say we, as well, the group is carrying this extra debt when it shouldn't be. The consequence of that is when Zagaleta wants to buy something from us, it's going to make a deduction for the extra debt, which we shouldn't have had, just as it would have done if, let's say, for the sake of example, the extra debt was £4 million. It's obviously going to do that, on the face of it.
I don't follow that. If what Zagaleta had bought was encumbered with the debt, it would obviously pay less.
Yes.
If you, the seller, have taken on the debt, it's not that what Zagaleta is buying is worth less. It's just that unless you make separate provision, you're left holding the baby.
In this case, the point is Zagaleta did take on the baby. In other words, what happens is, and this is the point my learned friend raises, they say, oh well, Zagaleta took on the liability of that €674,000. Which we say, exactly. And the quid pro quo, of course it's not going to be spelt out in terms in the agreement as such, but the quid pro quo is, I'm taking on your liability, so I'm not going to pay you 21 million.
The price was reduced.
Sorry?
So the price would be reduced.
The price is reduced, and we say that is the inevitable consequence, or certainly likely, prima facie consequence, of the fact that we're landed with a debt by virtue of the breach of warranty, which we shouldn't have had, just as if the debt was 2 million. It doesn't really matter. And I emphasise this because if you look at the Zagaleta agreement, it is very touchy about the level of debt that is being passed on. It's got a special adjustment provision. I can just show it to you. Because this is, I emphasise, not an income basing, this is not an income producing matter. And if I can just take you to page 120 of the bundle, the supplementary bundle, you can see it. The price is set out at 119, which you've seen before. Purchase price is 4.1. The purchase price for the Soto shares amounts to 20.6 million, 4.1, halfway up the page. Foot of the page, method of payment of the price, it shall be paid in the way that you've seen before, which includes the 8.8 million being essentially treated as part of the price paid to us, and then 4.3, adjustment of the price. Bank debt and so forth, and various other debts, shall carry forward, bank sell and so forth, shall be subject to upward and downward variation, 4.3.1, but 4.3.2, the non-bank debt of the company is excluding debts to RD Consulting and so forth, carried forward equal 2.3 million. Any upward or downward variation will constitute an upward or downward adjustment and so forth, and then there's a provision for that. So if it goes up or down, if your debt goes up or down, we'll make an adjustment. So they're assessing the price by reference to the amount of debt they're taking on. That is the point. And then 4.3.3 deals with the other debt. Again, it's making adjustments by reference to the amount of debt that actually it's inheriting. So I say, as one would expect, it's perfectly obvious. The fact that we've got an extra 674,000 euros worth of debt means that when Appellant do take it on, it is making a pro tanto reduction for that. That's the natural inference. And may I also make this point? It was never pleaded or suggested at trial, as far as I'm aware, that this debt should not be taken into account by virtue of Zagaleta having agreed to take it on. So these points are a new point. But in any event, leave that on one side. If it was a really good point, I accept. Okay, that's that. But this, in my statement, is a non-point. So I said there's no basis for reducing the sum of about 1.066 million, because that debt is a good. That the claim for, by reference to that undisclosed debt, remains good. My learned friend, just dealing now with the points of law. My learned friend says there's no finding by the judge on jurisdiction. I say, so what? This court is in a perfectly good position to do that. You just look at the documents. You don't need any help. As to the presumption of similarity, my learned friend says, well, we don't know what facts a Swiss court would have said were needed in order to prove the breach of the SPA. That's the whole point of the presumption of similarity. That you can't get out of the presumption of similarity by saying, who knows? You've actually got, and this is the point, you actually, as Lord Legger said, you have to show that there's a real likelihood of a material difference. Likelihood. Now, my learned friend hasn't even contended for the fact, or for the proposition there's a likelihood of a material difference. And there's no basis for saying there is any.
As I understood, this is really all about burden. You say we've got a claim which we're entitled to set off under Clause 8.
Yes.
And it's for you to prove that you've got a claim on the balance of probability,
yes.
so you can run set off. You say, look at the agreement, it was breached in the following way.
Yes.
And if nothing more was said about foreign law, the English court would just look at the agreement, decide whether there's a breach or whether there wasn't.
Not quite, my lord, because I think the passages which you were taken to in Lord Leggett's speech, I think, just going to the authorities, I think one understanding used to be what do I call the default position. That is to say, if there's no evidence of foreign law, you just assume full stop it's the same, without more. That, quote, default position was what Lord Leggett said in Brownlee was wrong. I think until then it had often been thought to be right. But what he does say by way of replacement is, albeit there's no default position, and therefore no burden of proof on one party or the other, nonetheless there will be a presumption of similarity.
Yeah, which if you say nothing, you are deemed to have relied upon.
Yes, and we have our point.
And then it's for the other side to say, no, you can't rely on the presumption, because in fact Swiss law is materially different from English law. They presumably have some sort of evidential burden to do something other than just simply assert that. But if they can then show that there's some basis for believing that Swiss law is materially different than English law in the relevant respect, your reliance on the presumption may turn out to be your undoing.
Most certainly, I agree. And that's why we say we have to rely. We do rely on the presumption, and for the reasons I've explained before, we say the presumption, we are entitled to rely on the presumption.
Well, you're entitled to take the risk that...
We've taken the risk. We've taken the risk, and we say, on the facts of this case, for the reasons I've given before, the presumption should be applied. There's no reason to suppose there's any difference in Swiss law construction, and so on and so forth.
Interpretation of a contract, you'd say.
Yeah, on contract.
But then, boot being on the other foot, you'd say, if the defendant runs a limitation point, relying on the presumption, then you'd say, well, hang on a second, Swiss law is likely to be very materially different in relation to a statutory regime for limitation. So I'm not sure you've actually, well, you say you have brought some evidence to bear because you asked the question of the witness who, that on any view that's good enough, you say, to displace the presumption that it might be 6 years or whatever else it was.
We had done what Lord Legate recommended.
I don't think probably I'd be surprised if Lord Legate anticipated somebody asking questions of a factual witness in cross-examination. But anyway, there we go.
Well, but he does, funnily enough, say a lot of these things can be just sorted out by looking online. Who needs? I mean, that is one of the points of his speech is don't let's get too worked up about foreign law and spending all this money on foreign lawyers when the answer is pretty obvious. And that's what we say. Not on limitation, but everywhere else it's obvious. But that I suppose perfectly right to do that. And my learned friend's problem is, even if you ignore Mr. Vernet, what's he left with? How's he proving his limitation defence? Because there's no proper basis for applying a presumption of similarity in relation to statute law-like limitations. Obviously not. So it works in our favour, on our points. It works against him, we say on his point. Now, we may say best of both worlds, but we say, no, that's how it works. So, that's what we say on the presumption of similarity. My learned friend says, by not calling evidence, we took the risk the judge wouldn't determine the point. That isn't right. The reason the judge didn't determine the point was because he didn't have to. But let us say this was the only point in the case. The judge could not have chucked it out on the basis of saying, I'm not going to apply or consider applying the presumption of similarity. He would have had to have dealt with it. So the fact that the judge doesn't deal with it, because he's made another finding which makes it unnecessary, is neither here nor there. My learned friend says this point was first raised in the closing. I think the better analysis is that Brownlee was not, I'm pretty sure about this, was not amongst the authorities in opening. We just said there's no reason not to apply Swiss law and say it's similar. My learned friends, I don't actually think specifically took the Brownlee point, but they denied. They just said it's Swiss law. So nothing turns on the fact that what you might say is the parties got round to putting their arguments on the correct footing by reference to the correct case, only at the end. But nothing turns on that. All the points of fact were well before the judge. I mean, and the judge makes the point himself, I think. Lot of trials took place to determine the various set-offs and write-offs and so forth. My learned friend often said, we don't know what Swiss law would say. How do we know? How do we know? To which my answer is, that's not the test. The question is there, I think, a likelihood of a material difference? My learned friend hasn't been able to show there is. And I submit that's the short answer to all my learned friend's submissions. I think I just make this point in relation to Brown, page 116, paragraph 208. What Lord Legate is talking about in 116 and 117, which my learned friend took you to, he's talking about the now outdated default rule when he's talking about burdens. Because he goes on in 117 and 118 to say, let's forget about the default rule. So the context in 116 is the default rule, which he then disapproves in 119 by saying we now go to presumptions of similarity, not default rules. I'm not sure my learned friend took it. But anyway, my learned friend refers to the Misrepresentation Act. I accept I can't rely on that in relation to Swiss law, but I don't need to. Finally, on the three debts, there's 3 point, whatever it is, 5 million. I don't repeat my submissions you had. In relation to the three other debts, the sequence was this. There was no defence, specific defence put in relation to them or reply by the appellant. Nothing said there. You'll recall what they say in their defence is, so what, we don't have to deal with all this. We did put in detailed material and our further information about it. There was no real opening by my learned friend in relation to these three debts. I mean, they took the point, none of it's liable, but they didn't take the point, hey, we're not allowed to pay them because the point my Lord Justice Snowden raised, or because they were taken on, or they weren't taken on. None of those points were raised. And this point came in only right at the very end. That's why you landed up with these various submissions at the end.
I mean, to be fair, an awful lot of water and argument are passed under the bridge on rather more central issues than these, so it's hardly surprising.
No, probably more enjoyable issues, if there's such a thing. I agree with my Lord. But the only point is a point of principle between my learned friend and myself. My learned friend says it wasn't dealt with or taken on in the Zagaleta agreement. Quite right. My point is simply this, and this is the point for you to resolve. We definitely took on these debts, no doubt about that, as, quote, assumed debts. Definitely took them on. The assets against which they were were sold by forced sale, and that's the only way we got rid of them. Query, is this therefore a debt we're entitled to write off against the purchase price? When I say write off, write down against in the net profit formula. Given that we have never repaid, given that the asset we paid for was sold.
They didn't relate
the only
to
way.
they didn't relate to the Soto shares, and they were charged on an asset that wasn't sold.
On the broad interpretation, yes, of this agreement. If you go to that broad interpretation, that's of course one reason I say this. The problem once is, how do you get to a sensible reconciliation if you take my learned friends approach? How do you get to a commercial agreement there? Because that I would submit would be completely uncommercial, and so forth. But if we're going down that route, I say we're entitled to. May I just say one point? I don't think the point has been taken before that that the loan, the assumed debts, were not acquired, and that is to say, by myself, by my client. From recollection, I believe my client charged all its shares, in fact, with the same debts. In other words, these debts were secured on various properties, but my client also had to had to secure the financing it took on, or the loans it took on. I speak from recollection that the reason I mention it is because this point hasn't been taken before. I can't actually precisely recall whether these debts were specifically added to the financing my client undoubtedly did have to take on in order to buy Soto. So, those are my solutions.
Thank you very much indeed, Mr. Knox. Thank you to everyone. Thank you to those who have spoken and those who have not, and for all the careful preparation of this case. We reserve our judgments. As you'll appreciate, in this court we circulate a draft for the identification of typographical corrections and obvious factual inaccuracies, but not for re-arguments. Thank you. And also we hand down matters these days electronically. We expect you to try at least to agree an order once you've seen the draft, and if you can't agree, put in very short submissions in writing, which we will deal with on paper only. I ought to just remind you about the draft when it's out and the very strict embargo in relation to that, and you should have already provided to our clerks a list of the people who are within the circle, so to speak, in relation to that. So if it is necessary, or you feel it is necessary, to share that draft with someone else, you must seek permission first. I'll just warn you about that. Thank you very much indeed.
Court rise at table.